The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Good morning. Welcome to RapidVisa Live. We are in Las Vegas, Nevada, where it is 10 a.m. Pacific time right now. We're once again live on YouTube and Facebook. We're here to take your questions. So if you're watching this live, go ahead and post your questions up there and we'll be happy to get to them. Just remember, we are not attorneys. We're licensed, bonded, registered document prep agency, and we can try to answer whatever immigration questions you might have. But just remember, nothing you hear from us is legal advice, and if you have legal issues, you shouldn't be getting your advice from the internet anyway. You probably need to get a lawyer. Okay, we'll jump right in. Rick is with me today, and Rick has wants to briefly discuss our most common question of the week, which is how does the government shutdown affect immigration?
Thanks, Ben. We've been asked quite a bit, as I'm sure a lot of you out there are wondering how the government shutdown is going to affect the immigration process and possibly even your petition. I just want to let everybody know, if you're a customer of RapidVisa, most likely your case is not going to be affected or impacted by the government shutdown, simply because the USCIS charges fees for all of their services for processing the K-1 fiancé visas, spousal visas, adjustment of status for green cards and lawful permanent residents. And the USCIS recently issued a memo back on December 22nd stating that fact, that none of their fee-funded activities would be impacted. So again, to our RapidVisa customers, that should not affect you. But there are quite a few cases out there that are being impacted. Just an example is that over 400 immigration judges have been furloughed. That has affected over 42,000 cases that were on the books or scheduled for a hearing. Those have been either postponed or canceled altogether, and they'll have to be rescheduled. We don't have any additional information on that. Again, it shouldn't affect any of our customers of RapidVisa, but it may affect some of the folks out there that may find our content on the internet, or they may even read this later on. There's also a few other visas out there that are being affected, like the EB-5, the investor visa. There was the Conrad waiver for the J1 doctors that are being affected, and the medical doctors, and I believe E-Verify and non-minister religious workers may be impacted. Again, this doesn't include RapidVisa customers though. So stay tuned and listen to the news, and I'm sure this is going to change. It's fluid right now as the Democratic and Republican parties are negotiating, and hopefully the government shutdown will come to an end very soon. But we hope that we don't see any more delays. Also, just to let you know, there could be some impact or effects on background checks. Now that could possibly affect some of our customers. Because as you know, you go into the USCIS stage in the Department of State, they do a background check on the U.S. citizen and the alien beneficiary. But that is the only thing I can think of right now that may impact the normal processing of a petition or application. Thanks.
Okay, so and once again, we're going to give a $100 credit towards a RapidVisa service. We'll select a person randomly out of the comments, even if you don't have a question. If you leave a comment or just say, hey, I'd like to be entered to win, and that's just kind of a fun thing we try to do. So $100 credit towards any new RapidVisa service. Okay, so I do have another announcement to make, and that is we have launched our green card renewal replacement service software. So we previously we were not, it was not something we did, which is help you replace or renew your green card. So now we've always done the renewal of your conditional green card, what's called the removal of conditions. But this would be for somebody who, your green card normally is a 10-year lifespan. If it's expiring, you need to renew it, we can now help you with that. Or if you've lost it, you need, or somehow you don't have it, destroyed it, whatever, washed it, and you need another one, we can help you with that. So we're happy to announce that new product available right now on our website. Give us a call about that if you have any questions or chat with us. Okay, let's jump right in. I'll let Rick take the first question.
Okay, our first question comes from Amaya. And Amaya asks, if my fiance comes to the U.S. With a visitor's visa first to visit me and my family prior to us applying for the K-1 visa, will that pose a red flag? Absolutely not. It's highly recommended that, well, first of all, to even be eligible for a fiancé visa, you must physically meet in person. It's also recommended that you meet multiple times. Now, if you're asking about if your fiancé comes to the U.S. and stays, that could possibly be construed as immigration fraud, or even though we've seen numerous folks apply for adjustment of status to get the green card when coming to the United States to visit on a tourist visa. I mean, it is quite common, but for your case, coming on a fiancé visa, I'm assuming that you're applying for a tourist visa first. That's how you would, come in to visit. But if you're coming in on the K-1, well, that is for the sole purpose to marry. With a K-1 visa, you have exactly 90 days to marry, and you must marry within that time. You cannot extend a K-1 visa, and then after you get married, then you file for adjustment of status. But your question did state coming in on a visitor's visa, like a tourist visa, B1, B2, or ESTA. I'm not sure where your fiance is from. But anyway, it's perfectly fine to come and visit on a tourist visa or a visitor's visa. You just don't want to overstay. That could cause some problems. So just make sure that you're just following the process and the rules, and you should be fine.
Okay, Amin asks, I'm from Algeria and I'm trying to do a K-1 visa. Is there something new about the K-1 visa? Well, there's nothing new I can think of. The fees are still, the filing fee is still $535. That's the fee you pay to the government. That hasn't changed in a couple of years. The income requirement does go up typically a little bit every year. But as far as the actual process, the procedure, it has not changed. You apply to the USCIS and you wait for that approval. Once that's approved, it's sent over to the embassy. And when I say you apply to the USCIS, that's the U.S. citizen sponsor, and you have to be a citizen to do a K-1. You can't do it if you're a green card holder. So you apply to the USCIS. Once that gets approved by the USCIS, it goes to the embassy, and then at that point, the alien, would then be called in to do a medical exam and interview, none of which are new. So all of that is the same. There's still a financial requirement. The sponsor needs to have 100% of the poverty level and income, proof of income kind of thing. So no, nothing's really changed. The only thing going on recently is the government shutdown, and as we mentioned, that should have a minimal impact on a K-1 visa. So no, I can't think of anything new in the K-1 sphere. It's rolling along as pretty much unchanged over the last few years.
The only thing we've seen change probably, I guess, in the last 6-12 months. Maybe it's taken a few months longer.
Yeah, that's true.
At the USCIS stage, it used to take about 4 or 5 months at the USCIS stage. Now it's taking 5 to 6. And then at the embassy stage, it's taken about another month. So you're looking at maybe 7 to 8 months as opposed to 5 to 6 months. But I think that's about the only change I could think of.
Yeah, and we're not seeing an increase in denial. We are seeing an increase in RFEs, requests for evidence, but most of those are ultimately resolved, and so we're not seeing a meaningful increase in denial. So yeah, it's a good a time as any to do it right now.
Okay, next question comes from Benjamin. Is asking, I want to know if my wife and I are married for more than 2 years and we haven't met in the last 2 years. I want to know if I can visit her since she is sick and unable to file. I'm guessing that you're asking if you can come on a tourist visa or maybe a visitor's visa. You can, but just keep in mind that a tourist visa is probably more difficult to get approved for. The process is very simple. It only takes a month to apply. You have the one form, the DS-160, which is an online form. You can fill that out, pay your $160 filing fee. You should get an appointment in about a month, and you should know whether you get approved or not shortly after the interview. But as I said, they're a little more difficult to obtain. You have to prove that you have strong ties to your country, that you're not going to come to the U.S. and stay or overstay at least the visa. You have to show you're going to go back. So having strong ties means that you have maybe a family there, a good job, a business, a home, assets. So you basically have to show to the consular officer that they know for sure you're going to go back. And in this situation that you just described to me, the consular officer is probably going to look at this and say, oh, you want to come and see your spouse who is sick? They may think that you're not going back. I'm not sure. I don't want to insinuate anything, but it could be a tough case. You may also want to explore the spousal visa. Now, keep in mind that's taking anywhere from 7 to 8, 9 months. It's taking a little bit longer, so that may not give you that may take too long for what you're trying to do. But again, we'd probably need some more information to give you a better direction on something like that. But based on what I've read, you're probably looking at a tourist visa if your spouse is sick and you want to get here quickly. It's probably your quickest and best option.
Yeah, you didn't mention the country, of course. If you're from a visa waiver country, you don't need anything. Basically, you'll be able to come over. But we're going to assume you're not, since you asked the question. Okay, the next question from Lizelle. Is it okay to apply for a K-1 visa and still have my visiting visa? Yes, you can certainly apply for a K-1 visa and a tourist visa. Now, you don't say if you're in the United States right now. If you are, it's still okay, but you will have to return to your country for the interview. There are no K-1 visa interviews done inside the United States. So, yeah, just don't overstay that visa. Now, if you're in the USA on a visiting visa and you've overstayed it, then you're in a different situation, and K-1's probably not what you ought to be doing. But yeah, if you simply have a tourist visa and you're either in the United States now or not in the United States, either way, having a tourist visa certainly doesn't keep you from applying for K-1. It's just that if you have not adhered to the terms of that, meaning you've overstayed, then you've got a different situation that you're going to need to look into. But just having a visa is perfectly fine, no problem with that.
Okay, Lucy asks or states that I'm a paying member with RapidVisa. I'm an independent contractor in the adult industry sponsoring my Canadian husband. Is my petition going to be declined because of my profession? I'm not aware of any reason or any information that would basically say that you were ineligible or would be declined or denied for a petition being in that type of profession. Usually they look at criminal history, criminal background. They're also going to check to see that you meet the income requirements. As long as you meet 125% of the poverty guideline, and and you can prove that with W-2s, 1099s, your tax returns, things like that. And then they'll also do a background check on your spouse, make sure there's no criminal history, criminal activity there. But I can't imagine your profession would prevent you in any way, shape, or form of getting approved. Again, as a disclaimer though, everything does come down to the discretion of the consular officer reviewing your case. They can and often do submit RFEs. That's a request for evidence. And what they're really looking for is usually proof of your bona fide relationship. They want to make sure it's a good faith marriage and that you're not just getting married to apply for immigration benefits or to get a green card, something like that. Hopefully that answers your question.
Okay, next question is from Anna. Is it highly recommended to apply for the AOS before the I-94 expires? It's it's not. It's kind of a situational thing. I mean, you're saying before the I-94 expires, but you don't say how you've entered the United States. You have an I-94, so you have an entry record, so you're here. So I can assume that much from the question. Certainly, a significant number people are applying after the I-94 date has passed. In fact, I would probably guess most, simply because typically it's only a 90-day stay, and it takes longer than that to ever get through any immigration process, really. So it's quite common that people are applying after their I-94, their exit date. So that's common. That in itself is not a problem. Now, is it 8 years after your after your exit date? Even that is not always a problem. We've seen people come. In fact, it's very common. People come on a tourist visa. 5-6 years later, they marry a U.S. citizen, and now they want to do an adjustment of status. They usually sail right through. So, speaking normally, in normal circumstances, it's absolutely not a problem if it's expired. But your specific question is, should you apply before it's expired? The answer really comes down to what kind of petition you're on. If you came on a K-1 visa, yeah, absolutely. As soon as you're ready, go ahead and apply. There's not a strict deadline that says when you need to apply after entering on a K-1, but you're going to be stuck here. You're not going to be able to travel or work until you do. So we would recommend you do it right away. So that's the best answer I can give you in that situation. But if it's been expired, again, we've seen them years and years expired, and the people have been in the United States basically out of status, and so they generally get approved. It's almost a surprise to us, and we were glad they do. But when we first started seeing them, when we first started doing the adjustment of status years ago, we thought, wow, this person has been here out of status for years. It's going to be a problem. And in fact, no questions even asked. They sailed right through. So every case is different, though. It's going to depend on your situation, if you've been in trouble with the law since you've been here, all those kind of things. But generally speaking, the date is not that important. Where it can become a problem, though, is if you've overstayed and you leave the country, now you have problems, because you may be subject to a ban of up to 10 years from returning if you stayed here out of status for a year or more, or if you stayed here out of status between 6 months and a year, it's a 3-year ban. So there are bans that apply if you out of status and you leave the country. But if you're in the country currently and you're talking about applying for adjustment status, which the only way you can apply for it is when you're in the country, then I don't think you have any problem at all. That's the best answer I can give you on the limited information.
Okay, Fortune asks, will it be considered misrepresentation during the AOS interview if one gets married after 60 days of legal entry into the state, but sends his petition for adjustment after 100 days? I believe Ben pretty much covered this rather well, but I'll just add a couple points to it. Basically, if you came in on a K-1 fiancé visa, okay, you have 90 days to marry, and you must marry within 90 days. Now, if you don't, that's not the end of the world. You're not going to get in any type of trouble. You can always come back and then file the I-130. Now, if you came in on a tourist visa or a visitor's visa, and then you get married, there's really no time limit, as Ben stated, on when you file the adjustment of status. But the important thing to notice here, or to keep in mind, is that the USCIS, under the current administration, is scrutinizing petitions more so now than we've seen in past years. And so I would recommend filing as soon as possible, especially if you need to work or travel. And especially when it comes to travel, and here's why this is so important. We have a lot of customers who come to the United States, they get married, but then for whatever reason they need to travel back to their home country for a family emergency. When they do, most often, in most cases, they cannot return legally. They cannot re-enter the United States without that lawful permanent resident card or the advanced parole card. So it's very important that you apply for the advanced parole, your I-131, and apply for your I-765, your employment authorization document. That will basically put in process to apply for the combo card. The combo card is about the size of a driver's license or a state ID card, and it does allow you to work and travel while you're waiting on the green card. So it would behoove you to apply for this as soon as possible, as soon as you're eligible. And to be eligible for it, you just have to be married to a U.S. citizen and be in a lawful standing, and you're good to go. So to answer your question, no, it's not going to look like a misrepresentation or anything like that. There was a memo that came out a while ago that talked about if you got married before a certain point after coming in on a tourist visa, but we have found that that really doesn't apply to folks that have come in on ESTA or the visa waiver program or something like that. But on a tourist visa, if that's what you came on, it sounds as though you've done everything correctly. You came in, you got married, filed for adjustment of status, and you should be fine.
Okay, Lizelle, another question from Lizelle. I believe this is the same Lizelle. The last time I was with my fiance was July of 2017. Is it okay to apply for a fiance visa at the end of 19, or would it be wise to visit again at the end of 19? You can't apply at the end of 19. The 2-year meeting requirement when you file is extremely strict. In fact, I read, it's been a little while back, but I even read an appeal where a person had gone over by just under a month, about 28 days I think it was. They were over the 2-year limitation. In other words, it had been 25 months, basically, just over 24 months, since they'd seen their fiance. They applied, were denied. They even appealed it and spent all that money to go to the Board of Immigration Appeals. It was still denied. They are really hard about that rule. So absolutely, if the 2-year marks up in June, you will not be accepted if you apply in December. It's not going to happen. So you need to apply before then, before June, get it in there. And if for some reason you can't do that, yes, you're going to have to make another trip. Don't waste your time and money applying, because that's one rule that we've never seen them budge on it. 2 years, and you need concrete evidence that you met. Chat logs and various things aren't going to do it. You're going to need to show your travel documents, a stamp that you entered the country, or they came here, whichever. Doesn't matter where you meet. You can meet anywhere in the world. Photos together. I mean, you need good evidence. That is one thing that they don't give any ground on. If you can't prove with certainty you have physically been together within 24 months of filing, you will not be approved.
Okay, Revitalize asks, my Philippine alien beneficiary is going to be 25 years old when we marry and plans to do a spousal visa. Does she still need parents' consent? Both of her parents have passed. This is a very good question. And I can tell you that when I brought my spouse to the United States from the Philippines, she was over the age of 25 and did not require the parents' consent. Now, having said that, I highly recommend that you check on the Civil Registrar's website in the Philippines. You can just Google that, look it up, and they have step-by-step procedures for any marriage in the Philippines. You can also go to the U.S. Embassy in Manila, and there they have the step-by-step procedures. I can tell you this, when I brought my wife to the States, we did have to attend a seminar, though. It was a 2-hour seminar, and about relationships and things like that. But from what I remember, if you were under 25, then you did need a parental consent. But I would just check on that to be sure. I mean, we work with over 174 countries, and we can't be familiar with every rule and law out there for every country. But Philippines, we do process quite a few petitions there, and I brought my spouse from there and actually went through a spousal visa, and I'm just sharing with you the experience that I went through. But just check to be sure, because I don't want to give any misinformation.
Yeah, and I'll weigh in on that just a little bit. There is no such requirement from the United States. This is a Philippine requirement. They're going to ask for that when you go to the CFO seminar, which is the Commission on Filipinos Overseas. You could just always ask them. They have a few offices. Drop in and ask, or check their website, or try to call them and ask. I'm sure that's happened, and I'm sure there's a way. If she is going to be 25, since she will be 25, I actually think you're fine. I think the rule is under that. But again, it has nothing to do with U.S. immigration. U.S. immigration laws only stipulate that you both be of legal age to marry, and which you both, well, I don't know what your age is, but I'm assuming you are 25, certainly legal age to marry, including in the Philippines. But this is an in-country requirement. Before you can leave the Philippines on a spousal visa, fiance visa, the Philippine government, not the U.S. government, does require you to get clearance from the CFO, which involves going to a seminar, and they're going to give you a little paper and they're going to put it in your passport. And when you go to leave the country, when you do go to the customs guy to exit from the airport in the Philippines, they will not let you go without that. So that's how they're enforcing that. It has nothing to do with the U.S. government. You can certainly get into the United States without it. You just can't leave, many countries, but not the United States. You go through a customs process when you leave the country. We don't do that here, so we're not familiar with it. We only go to customs when we enter the United States. But in the Philippines, as in many countries, maybe most, you also go to customs when you leave. And so that's how you would have trouble with that. But CFO clearance is what you need. I would just check with them and find out. I think at 25, though, I think you're fine. I think the last I remember, and again, it's always hard to remember all these local little rules, and I'm sure we actually have people who know that, who do this every day here on staff somewhere, but I thought it was under 23 or 2 or somewhere in there. I feel pretty certain you're fine at 25, but just check with the CFO office and they can clear it up. Okay, John. Michelle asks, was it John? Okay, well, either way, I will be married. I guess that was a quote. I will be married next month in the Philippines. Do you know how long the PSA is taking for the official marriage certificate? I will need this before applying for the CR1. Yeah, we have a great deal of information in a long article on getting married in the Philippines, just because we do the Philippines so much. And I think most of it, in fact, was written by Rick here because he got married there. You are going to need a few weeks. 2 weeks would even be tight, because you've got to apply. There's a waiting period before you can get married, where they post it. I guess, assumably, just in case there's any objections, they post your permit, your application, and so on. So it's not like the United States, or it's not like Vegas, where you can do a drive-through wedding, and which is you can actually do here. I'm not joking. It's a process there. They have a lot of public holidays, and there are some jurisdictions, believe it or not. I think off the top of my head, I think Quezon City might be one of them, where they won't even perform marriages for foreigners to Filipinos. So you got some hoops to jump through. I would research that first before you start taking off work, because just thinking you'll go there and in 2 weeks you'll come back and be married, it may not happen. It might take you 3, it might take you 4. The bureaucracy there is notoriously maddening, and you're just going to have to allow for a lot of time. That's why from the Philippines the K1 visa is much more common and popular. However, I don't want to discourage you from it. I'm just saying, do your homework, get stuff lined up before you go if you have a limited time. Now, if you're retired or can take self-employed or whatever, you're in a situation where you can stay as long as you need to get this done, then yeah, absolutely. You can absolutely get it done, and in the long term, a CR1, getting married there, will save you money, because you won't have to do the adjustment of status. So I'm not trying to discourage you from it. I'm just saying you got to have some time. Don't book a return flight unless you can book it like a month later. If you try to go and you got 2 weeks off and you're booked a return flight, 2 weeks is tough. I'm not saying it can't be done. I'm sure there are people who have got it done, but you're going to have to look at the Philippine holidays, because there's 14 of them. And then occasionally they just come up with a special holiday, like when the Pope came, they just declared it randomly a holiday. So, they have strikes, they have transportation strikes, all kind of things happen there. The gears are not greased very well in the Philippines, unless you got some money you can grease them with, which I don't recommend. So yeah, you can absolutely do it. But you say, how long does it take? Again. To get that marriage certificate in your hand is not just a matter of the PSA issuing it. It's a matter of you going through all the steps necessary to get there, which includes that. How long do you have to post it? Is it a week?
So it's 10
days?
business days, and I actually showed up in 12 days, not business days, and found out it turned out to be 2 weeks, because you add in the weekends.
So it's basically a 2-week waiting period where they have to post it, publicly post it. So that tells you right there it can't be done in less than 2 weeks, and it's questionable if you can get it done exactly 2 weeks. So So there you go. If you've got an open schedule for whatever reason, your flexibility allows you to be there 3 or 4 weeks, then absolutely it's a good way to go. You'll save some money, and I recommend it. But if you don't have, if you're a regular guy like most of us, where you have a job and you got to be there and you've got a limited amount of vacation time, you know, you may want to really think about doing the K1 instead of the CR1. If you need a ceremony for the family, which is a common, what many people have done is do some kind of ceremony. Even to all attendees, it could appear to be a wedding, but you just don't actually get married, and don't talk about being married, and don't go showing pictures of a marriage license, because if the embassy thinks you got married, even, they'll deny a K1. So you have to be clear to everybody that this is we're having a ceremony, and call it an engagement ceremony or whatever you want. So that's one way people have got around it. They've done the dress, the whole big ceremony, but they didn't actually get a license, get married, register it, do any of that. Just have a ceremony so that the local family can attend. That's one way people have kind of solved this dilemma. But we wish you luck with it. And if you have more questions, just go ahead and add them there or give us a call.
Now, just to add on to that, there's 2 different types of licenses and certificates in the Philippines. The first marriage license actually comes from the civil registrar's office. You can get that at kind of like the county courthouse or the local office there. My wife and I actually obtained our marriage license from the city and county building in Manila, in Metro Manila. And then once we received that marriage license, we were married by a judge and a magistrate. And so once you get that marriage license or certificate signed, it's not an official marriage certificate at that point. Then you have to have the civil registrar's office transfer the certificate over to the PSA. The PSA is the Philippine Statistics Authority. They keep all the records, civil records, in the Philippines. They're one of the few countries that I'm aware of that actually has a marriage registry. So then they register that at the PSA, and right now, it's my understanding it's taken approximately 2 months to obtain the marriage certificate from the PSA, and that's a little different from getting the marriage license, which Ben covered very well. It takes a couple of weeks just to get that. So in your question, Michael, you stated that you're going out to get married, so we kind of assume that you're looking for the steps and procedures for being able to get married. So Ben covered that very well, but if you're actually looking to get the marriage certificate from the PSA, you can add another 2 additional months on top of getting married. So this is a very long process. This is not for the faint of heart, and you've got to have some time to do it. Now, the good news is you do not have to be in the Philippines during this period. But you do need to show up to sign the paperwork to get the marriage certificate. You need to be there for the marriage, of course. Then you can travel back to the U.S., and it's just going to take some time to get the actual marriage certificate from the PSA. Your spouse can do that. You can actually order it online once it's available. I know my wife went down there several times and escalated to a manager because it was just taking so long, and we wanted to get moving with the process. But I hope we covered both areas there for you. If not, give us a call. We can clear this up. Okay, next question comes from Muhammad. Does a joint sponsor have to live with me or in my state? Excellent question. We get asked this quite a bit. And the answer is no. The joint sponsor does not have to live with you, does not have to be in your state. Basically, the requirement is that they must be 18 years of age, must be a U.S. citizen or a lawful permanent resident, and of course, they need to meet the income requirements. If you're filing for a fiancé visa, that is 100% of the poverty level. If you're filing for a spousal visa, that's 125% of the poverty level. So no, they don't have to live with you. But it will depend on which country you're from, on which form they require, and if you're which visa type you're filing. If you're filing for like a spousal visa, they're going to be filing the I-864. And if you're filing for a fiancé visa, you're looking at the form I-134. So there's some different requirements there, depending on which visa type you're applying for. And in some countries, they actually require the I-864 for the fiancé visa. I'm not exactly sure why some consular officers have different requirements, but that's the way it is. Some of these things are not written in their instructions or their documentation. We've just learned this by doing over 40,000 cases successfully. And basically, if they ask you for a different form, don't question it, don't argue with it, just provide them with what they're asking, and hopefully you get your approval notice shortly after that.
Okay, from Mylene, she asks, we got an NOA2 and NVC notice. My fiance is still waiting for the 2018 tax return. Do we need to wait for that for the affidavit of support? We are a RapidVisa customer. Well, first, I'll thank you for being a RapidVisa customer, and thank you for your question. Sounds like you're moving right along in the process. Congratulations for that. It's a common question this time of year. So, number one, it's not even possible to file your 2018 tax return right now. The earliest filing,
28th.
28th or something. It can change a little bit each year, but employers are not required to send out the 1099s or W-2s until the end of January. So for most people, it means you're not even filing until February. Then you add, 2 weeks to 2 months to get that back. So it could be several months before he gets it. So the short answer is no, you don't have to have it right now because legally you're not even required to file until April 15th, possibly later if you file an extension. But what you should have, or will have by law anyway, or should have by law, by the end of January, or maybe the first few days of February allowing for the mail, is his W-2s or 1099, or however he or she earns their income. And so you do need and you will need to show the proof of income for 2018, but it does not have to be a tax return simply because it's not even possible to have one at this point. So don't worry about that. Go ahead and get your interview scheduled for as quick as you can or as quick as you're comfortable with, and don't forget your medical exam has to happen first. And then gather up, have your fiance gather up whatever financial evidence they have for that I-134. And of course, your customer, you call us, we'll help you with this, but and prepare that I-134 for you. But typically, if he works a regular job, that's going to be W-2. If he's some kind of contract employee, maybe that's 1099, or if he's retired on some kind of benefits. There's always documentation for those things. If you're self-employed, it's a little tougher, but still, we can help you through that. So no, definitely don't wait on the tax return. Only the tax return. You want to get on with this as soon as possible. Technically, the USCIS approval is only valid for 4 months. However, if you're delayed getting in the embassy because of the embassy, they routinely extend those. But if you keep putting it off, be aware that if you read right on your NOA2, you called it, which is your approval notice, you'll see that it's basically a 4-month approval. It is not valid forever, so you don't want to drag your feet. You just want to get busy and get in there and get it done, and you'll be fine with your income if you have other evidence besides a tax return. And even if you had the tax return, you still have to have the evidence. The tax return alone is not sufficient. The tax return has to be accompanied by the third-party evidence, because you prepared a tax return, it could be a work of fiction. That's why it always must include W-2, 1099, or bank statements if you're self-employed, some other things. So it's not actually even the key piece of evidence. Now, a tax transcript, that's different. You get that back from the IRS, and that is a more solid piece of proof. But anyway, no, you don't need the 2018 tax return, not yet.
Okay, Sharina Prater asks if the documents we passed to the USCIS and U.S. Embassy in Manila are going to submit again for adjustment of status. Yes and no. The reason why I say yes is because a lot of the same documents will be submitted for your adjustment of status. The only difference is that you want to have current documents. Okay, for instance, especially your income. Well, if you've just gone through the K-1 fiancé visa process, you probably just spent 6 to 8 months going through this long process, and now all the documents that you submitted, back then, are probably out of date. And usually, when you're submitting your financial documents, you want the most current documents. And also, for your adjustment of status, of course, you're going to have a new marriage certificate, so that'll be new. Now, when you use our service, we give you a very detailed checklist that's going to be customized to your scenario, and it's based off the answers that you provide in our proprietary online questionnaire and with our software. So you'll just print out that checklist and you'll run with that. But to answer your question, when you go through the adjustment of status, it will seem like a lot of these documents are the same. It's just they're just going to be renewed or more current documents.
Okay, we have a question from Facebook from Steve. Steve asks, I'm an American citizen. I'm making plans to meet my fiance soon. I have a domestic violence on my record. Will this be a problem? Well, congratulations on your pending engagement, Steve. We've seen that a lot. It's typically not a problem, but you know, there are degrees, right? I mean, you know, if domestic violence if it was a felony level thing, a person did time for it, stuff like that, yes, it could have an impact. If it didn't rise to that degree, which most don't, you know, a complaint was made, you know, during a divorce or something, and a restraining order is issued, those kind of things are quite common. That alone would not stop you. So to answer your question, there's not a rule that says, hey, if you got a domestic violence, you absolutely be denied. And we've seen quite a few approved with it. So I would not let it discourage you. Now, if it's something real extreme, then, you know, felony, you know, these kind of things, and again, we're not lawyers, but if it's something to the extreme, yeah, it could impact it. I mean, they're using their judgment. They want to ensure that the alien is safe, or they're not allowing an alien to come here and get into a difficult situation. Now, I will say you are required on your when you do your petition for alien fiance, the K-1 visa we call it, you are required to disclose that and provide documentation of the disposition of the case, so whatever you have. If you don't have it, you'll have to go get it from the court if there are in fact records like that, and you say there is some kind of record. And then what they'll do is they'll give that to your alien fiance. So the International Marriage Broker Act, IMBRA commonly called, requires that this information be passed along to the intending immigrant so that they are fully informed, you know, in case you haven't discussed it yourself. So one of the things you'll want to do, or at least I suggest, is discuss this with your fiance, explain what happened, because she or he will be provided with that information, because you're required to provide it in your filing, and you don't want to leave anything out because they are going to do a background check. You provide it, they pass it along, so she or he are going to have that stuff in their hand, and so you'll want to be talking about that and make sure you have an open discussion about all that. But it shouldn't discourage you from filing, not at all. We've seen it many times, and they usually go right through.
Okay, Manal's asking the time difference for processing between a green card holder and a U.S. citizen for a CR1 spousal visa. Actually, this is kind of a tough question to nail. I know on average you're looking at about 8 to 10 months if you're a U.S. citizen applying for a CR1 visa, and if you're a lawful permanent resident or a green card holder, you're looking at somewhere around 2 years. And the reason why I say it's difficult to nail this is because if you go out and look at on the USCIS website at their processing centers, and they have multiple processing centers where your petition can go, they all list different time frames. And then they also have a website and a spreadsheet with different family categories, and you can go down through the categories and see where the priority dates are. But right now, I'm just giving an average, and please don't hold me to this because it's probably going to be longer, but you're looking at about 2 years for a green card holder and about 8 to 10 months for a U.S. citizen. So if you're close to getting your citizenship, it may behoove you, or it may be to your advantage to go ahead and apply for that U.S. citizenship, because that in itself is taking about 6 to 8 months to get your naturalization, and then that may put you well ahead of the curve on the spousal visa, because right now, like I said, the estimate is 2 years. It could be even longer than that based on the processing center, because some of the processing centers are so far behind.
Okay, from YouTube, Revitalize asks, I'm a U.S. citizen. If I get a spouse visa for myself, does that conflict with getting my wife a spouse visa to come to the U.S.? If I get a spouse visa myself. Okay, so I think what you're saying is you originally came to the United States on a spouse visa, and I apologize if I'm not getting this right, add another comment and we'll try to readdress it. But it sounds like what you're saying is you came on a spousal visa, and now apparently that relationship has ended, and now you have remarried, and you want to an alien, and you want to bring that person on a spousal visa. So the short answer is no. If you are a U.S. citizen, you enjoy all the rights and benefits of being a U.S. citizen. You absolutely can petition anybody you want on a spousal visa. Now, having said that, of course, you know, they look at the whole case. I mean, if you came here on a spousal visa and there are some indicators that might have been a fraudulent attempt just to get citizenship so you could then bring somebody else here or whatever. I mean, those things happen. We've seen cases where people will be in a foreign country, divorce their spouse, marry somebody to get a citizenship, and then as soon as they got that green card, they divorce that person and then remarry and reapply for the original spouse, right? I mean, that's actually happened. Not with us. We follow these news stories, and so, yeah, I mean, as long as everything's on the up and up, you did have a legitimate relationship in marriage with the person who petitioned you initially, but for whatever reason, death, divorce, whatever, you're no longer together, but it was legit at the time and all of that. Yeah, absolutely, no problem. You know, they look at all the information they have, of course, and they're always looking for people's, you know, attempts to defraud the system, of course, and so, you know, if there's anything like that going on, I don't recommend you do any of this. But yeah, if it's just an honest relationship that didn't work out and now you've remarried, yeah, absolutely, you have every right to apply again. And we've seen that many times. So it would not be, and which means they've seen it many, many more times. So it's not going to be any big red flag. So yeah, absolutely, go ahead and do it.
Okay, Sheila states that we have received our NVC welcome letter last week. Congratulations. And she's asking, do we have a due date to pay the fees on the U.S. Department of State website? That's the CEAC website. Thanks for your assistance. Yes, you absolutely do have a due date. As Ben had mentioned earlier, when you receive your NOA2 letter, your approval notice from the USCIS stage, that approval notice is valid for 4 months. Okay, that means you have 4 months to get through the MVC stage and then through the embassy stage, which includes the interview. Now, as Ben mentioned before, if your process is delayed by the Department of State, which is over the National Visa Center and the embassies, then they'll almost automatically extend that validity period. However, if for whatever reason you delay the process, it is at their discretion to cancel your case and send it back to the USCIS whenever. So basically, yes, there is a due date. You need to have this paid, all the fees paid, all your documents submitted to the National Visa Center, and before that validity date expires. And what's going to happen is the National Visa Center is going to gather all these documents, gather all these fees. Once they have everything and it's all complete, then they reach out to the embassy and they'll schedule your interview. Now, once you get to that stage, you know, you can contact the embassy and let them know that you're still pursuing this. In most cases, they will keep your case open for up to a year. As long as you're actively pursuing the visa and the immigration benefit, they will keep it open. But with MVC, they're not going to wait around too long. You've got to pay the fees because that's how they get paid to process and review your documents. So if you want this to move forward and not get you know, denied or sent back, pay the fees and get your documentation in as early as possible.
Yeah, just understand that this is not a two-way relationship you have with the government. They are going to take their time and drag their feet and be excruciatingly slow at every step. But when it comes to you, they're going to give you deadlines, and it's going to be in your best interest to do things as quickly as possible. And so it's a little bit unfair. They go so slow and then want you to move quick. But that's the way it is. So you know, pay attention to deadlines. They are important and usually not flexible. And don't put off anything. You know, if you're at some step and you can do it tomorrow, do it tomorrow. By all means, don't think you have a lot of time to wait, because in the interim anything might happen. Okay, Michelle from Facebook is asking, if we're going to pass our AOS, is it necessary to have a joint account for evidence? So I assume you mean joint bank account. It's not necessary. There's no exact check mark, or rules, and you got to check each one of them to get approved for the adjustment of status. They're looking for a legitimate relationship. So certainly commingling of funds is one of the things they look at. It's not required, but they're looking at a bunch of things. Are you living together? Of course. Now that is important. Again, not technically required, but it's going to be tough if you're not. Have you commingled your funds? Have you do you have your names on each other's on a lease, if that's applicable? Apartment lease or whatever. Car insurance, life insurance, health insurance. You got to have some things. If you don't have a joint bank account, that's okay if you have other good evidence. If you don't have other good evidence, I would suggest you get on the bank account, because you're going to need everything you can get. If you've had a child together, that's probably the best evidence. But of course, many people don't at this early stage. So I'm not saying you have a problem if you don't. But yeah, you want as many things in your favor as possible, because the really one and only reason they're doing this interview is to make some determination of, is this a legitimate relationship? Commingling funds typically does mean there's a level of commitment. Now, a lot of people, even people who where everybody's a citizen, are not applying for any benefit. There are certainly a lot of people who choose to have separate bank accounts, but they're not trying to convince the government they have a legitimate relationship. So, I would recommend you get on the bank account, but if that can't be done for whatever reason, then no, it's not an absolute requirement, but you do need to have something else going in your favor. This can't look like a roommate situation. There needs to be commingling of your life in meaningful ways to convince the adjudicators that this, in fact, is a legitimate relationship.
Okay, Tatinda asks or states, does calling the USCIS for case updates regularly help to speed up processing time for one's adjustment of status? Somebody recommended that. No, it does not. Actually, it's best if you'll just check the status online. You can go to the USCIS website, enter in your USCIS case number, and you can obtain the case status right online. Just calling in to the USCIS is probably just going to make you lose your mind and get more frustrated, because a lot of times if you call, you'll experience long hold times. And then when you do actually reach someone, the frontline or tier 1 customer service reps that they have, the USCIS, they can merely read from scripts, and they cannot give legal advice, and they're not even going to be able to tell you your status other than what you can find online. And in most cases, you're not going to get a hold of the actual processing center that's processing your case. The only way to do that is probably schedule an info pass meeting with your local office. But even then, we've heard from some of our customers that have done this, said that they were just told to wait for the processing time. And just to set your expectation and everyone else that's out there, if anybody tells you that they can make the government move faster, they're flat out lying to you. I don't care if they're an attorney or a document preparation company. You just can't do it. They're working on their own timeline, as Ben mentioned before, and it is just painfully frustrating. They move on their timeline, not yours, but usually you're given timelines and deadlines that you must meet. And whatever you do, do not miss an interview for adjustment of status, because it's canceled. You've lost your money, your fees. You start over from scratch. But to answer your question, no, it doesn't help to call the USCIS. It's highly recommended that you just check the status online. Now, having said that, for a full disclaimer and to cover ourselves here, if you don't hear something, if something hasn't changed online with your case in a while, then yes, absolutely call the USCIS, schedule an info pass meeting. Do not sit here and wait 6, 8, 10 months, because then you may find that they issued an RFE letter, you didn't receive it, you didn't respond, your case was closed, you didn't even know about it. Okay, but if you're just checking every week, I believe you said every on a regular basis, do that online. But after 3-4 months go by and you haven't received your combo card yet, some people have called us and said we didn't receive our receipt notice, within 2 to 4 weeks. Okay, that's a red flag. Time to call. Do not wait forever. So I don't want to make it sound that way. But if a certain amount of time is called or gone by, make sure then you call, schedule an InfoPass meeting, because you need to get these documents, whether it's your NOA1, which is your receipt notice. It's very important. And oh, by the way, for everyone out there, keep these documents. Okay, do not make the mistake of discarding these, throwing these away. Keep your NOA1 document, keep your NOA2 letter, and then you should be receiving your combo card in about 3 to 4 months after submitting your application. And then you should have an interview approximately a month after getting your combo card. And then after your interview, you're probably looking at about 2 to 3 months to get your actual green card. So if those steps have not come to fruition and you haven't received those items I just mentioned, then by all means pick up the phone, call the USCIS, be prepared to wait on hold, and and then just hope for the best.
Yeah, and for each service center, they do have their estimated wait times, or their processing times, they call it. If you're beneath that, if they say it's taken 6 months for an I-130, for instance, and you're less than 6 months, they're hardly going to give you the time of day, really. Now, if it's 8 months and they say their processing time is 6, then yeah, maybe it's time, like Rick says, don't wait forever. But if it's been 3 months and they're saying published online for that service center that the processing time is 6, you're just wasting everybody's time by calling or contacting your senator or any of that. Nothing will work if it's below the processing time. You won't get anybody's attention, and they'll resent you for calling, basically, is what we see. So, unfortunately, it takes a while. Unfortunately, you're not as important as you might think you are. None of us are to the government. And so it doesn't matter if you're pregnant, sick, whatever. They're not gonna speed things up. So just try to have some patience. It's tough, but it's the best advice we can give. Okay, Cyril. My fiance is 76 and I'm 27, but our relationship's real. I'm worried. What should I do? Well, age gaps are really common. In fact, they are the rule rather than the exception. For whatever reason, in these types of visas, we almost always see an age gap that would be larger than maybe what you normally see, and that goes both ways. When the U.S. citizen's a woman, there's usually a larger age gap with the male intending immigrant, and vice versa. So it's for whatever reason that happens, I don't know, but that is how it is. And so now your age gap is pretty big. Honestly, it's about 49 years. So that's a little larger than we see, but it's not a record. We've seen them, and we've seen them go through. So the first thing I would say is no, there's no rule against it, but you will, they look at the totality of the case, and you want to make sure you've got a lot of extra good evidence anytime your case is maybe a little outside the norm. Not just with age, but with anything. If there's anything about your case that may be different, then it's going to be in your best interest to go above and beyond with other types of evidence to maybe compensate where your case might be a little weak. So yes, of course, it would be natural of any adjudicator, any person to say, 7627, is this something that's just going on for a green card here, or what is this? But that's okay. You can overcome that, and people do all the time by having good, solid evidence, having a good interview, meaning you know a lot about each other and those kind of things. So you can always call us for more information on that, but basically it is common. 20 years or so is very common and doesn't appear to slow anything down. Nobody even looks at that. At least that's been our experience. You start getting up a little higher, like you've got 49 years. That's a little more, but still we've seen that before, and we've seen them approved before. So don't count yourself out. Just make sure all the rest of your evidence is good.
Okay, Beyond Real states that my fiance is expecting, but we don't want to vaccinate the baby, so when we start processing the K-1 paperwork, will it become a problem? The short answer is no. You can decline the vaccination shots at the medical exam, and also, just so you know, it states that you're in the process. So the medical exam and vaccinations are at the very end of the process, okay? This will usually happen approximately 5 to 10 business days prior to the interview and before the visa is issued. So this is going to be something at the very end. But you can decline the vaccination shots for the K-1 fiance visa. Now that'll be another story when you get into the United States and you go to adjust status and apply for the green card, because in most cases you'll either have to get those vaccinations or you'll have to get some form of a waiver. And based on our experience, it's kind of difficult to get waivers for certain things like that. But as far as the K-1, which you mentioned, and the paperwork, this shouldn't slow your process down at all. And then you mentioned the baby. So you mentioned the fiance is expecting, but you mentioned getting the baby vaccinated. So I'm not sure when the due date is on that, but when you get to that stage, if the baby's going to be a U.S. citizen, then you'd want to file for the consular report of birth abroad, but that's a whole different process and outside of this question. But that's something we could assist you with as well. But
yeah, and just to follow up a little bit on the vaccination thing, you can, as Rick said, you can deny it at the K-1 because technically a K-1 kind of falls in this little gap where it's considered a non-immigrant visa, even though your intent is to immigrate, and vaccinations aren't required in that circumstance. But to get the green card later, you will have to either get the vaccinations, which will now be additional costs, which probably would have been included with your initial medical exam, or you apply for the waiver, and I think it's $600 or something. There's a fee. You fill out the form and the waiver, and you ask for it, and they may or may not accept it. But it is expensive, and you will have to document your case, and it's kind of mixed results. What I would say, and what I've said to people when they ask this, if you have very strong conviction about this, then yes, fight it, and you'll probably be successful. If you're kind of on the fence about it, understand you're going to delay your case. You're going to cost yourself hundreds of dollars, probably $1,000. I mean, you're going to have to go to a doctor and get the medical exam and everything, and then get some kind of, prepare this waiver, which you're going to either do yourself or pay an attorney to do. It's not something we can do for you. And then you're going to pay that fee, which I think is $5.95, $6. It's been a while since we've done one. It's not cheap. So it's going to cost you money and time. And if those are your strong convictions, then you can probably make it happen. But if you just kind of on the fence, like, well, I'd rather not, then you might want to rethink it because it's going to make things go a lot slicker. And you're going to have trouble everywhere getting into school, everything without vaccinations eventually. And not that you can't overcome those things, but you need to have a strong conviction if you want to fight that fight, because you are going to bump up against it in a lot of ways if you start not vaccinating your kids. Okay, let's see, where are we at? I'm kind of lost my place. Oh, here we go. Oh, okay. So time to wrap it up. Sorry, the time gets away from us. We try to keep these things to an hour. So we'll wrap it up now. I want to thank everybody who entered. And do we have a winner of our? The winner is, oh yes, we do. A giveaway announced, a $100 RapidVisa credit for any future product. Chariz, M-A-B-A-N-S-A-G, Mabansag. Chariz Mabansag. Okay. Thanks, Chariz, for your entry, and we want to once again remind you that we've done over 40,000 of these. We feel like we know a lot, as much as anybody probably, about the particular types of visas we do. But we're not lawyers. It's not a law firm. And even if we were, you shouldn't be getting legal advice from a guy on the internet. If you got any legal issues, legal questions, by all means, find yourself an attorney. Thank you. Once again, we always appreciate our viewers, and if we didn't get to your question, please feel free to call us or chat with us anytime. No obligation. Thank you. Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. RapidVisa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at RapidVisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with RapidVisa. There's no cost or obligation to create your RapidVisa account. You can create your free account at RapidVisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you, and see you next time.